All right, your name, sir?
Roger Howard.
All right, sir, you've got a set of charges here. Possession of concealed weapon or firearm by a convicted felon, bond $5,000. Aggravated assault with a deadly weapon, bond $150. And petty theft, bond $100. I don't have any application for criminal indigent status. Has the public defender represented Mr. Howard, or, yes, Mr. Howard before?
Sorry for the delay, Your Honor. All right, let's see here. Ready to proceed?
Say again?
What was the question, Your Honor?
Does the public defender have a record of having previously represented Mr. Howard?
I do not have any records at this time, Your Honor.
All right. Well, I'm going to, in light of the circumstances here and the allegations, I'm going to temporarily appoint the public defender to represent Mr. Howard, and that is Division 10.
Wait. Sorry. Wait. Apologies, Your Honor. The paperwork was not in order. There were some delays in my office this morning. One moment. I'll be right there. All right. Here we go.
All right, the next case is that of Nina Williams. Is that you, ma'am?
Yes, sir.
All right, ma'am, you've got a set of charges. A battery on an officer or firefighter or EMT with no bond, resisting an officer or obstructing without violence, no bond, resisting an officer with violence, no bond, resisting an officer or interfering with an officer without violence, no bond, and disturbing the peace, breach of the peace, no bond. Now, in regard to these allegations, do you want me to appoint a lawyer to represent you?
Yes, sir.
All right, Office of the Public Defender is hereby appointed, and that is Division 22.
Your Honor, my client qualifies for PTR at this time.
All right, State?
Your Honor, as these contain crimes of violence, the state would oppose pretrial release. However, the state would recommend the court set bonds, as she is entitled to bond. The state would recommend as to count 3 that bond be set at $2,500. Counts 1 and count 1 at $150 as a subsidiary. Counts 2, 4, and 5 at $100 each, Your Honor.
Your Honor, with respect to my client's current record, she does not have any, one moment, actually. Yes, my client does not have any currently listed Florida state's arrest at this time. She does not have an extensive criminal history. This appears to have been a one off incident. Would it be possible for Your Honor to allow my client to go on PTR at this time, considering that she is at this moment currently unemployed?
Well, in regard to the bond situation, and considering the nature of the charges, the court would set bond, count one, $150, count two, $100, count three, $2,500, count four, $100, and count five, $100. And that is Division 22, if I had not previously announced that. Joel Menjivar?
One moment. I think it's- Apologies. Let me see here. Without violence. Apologies, Your Honor. I believe there may have been a clerical error as to the resisting an officer with interference with a law officer without violence. That her charges mirror that of her father's, who was also on the scene. I believe that the officers may have simply revised all the same charges on the same sheets.
All right, and State?
Your Honor, as best as I can tell from the four corners of the affidavit, the resisting with violence does apply to Ms. Nina Williams as well, Your Honor, as does the battery on a law enforcement officer, firefighter, or EMT, both of which are crimes of violence.
Your Honor, I was not speaking of the resisting without violence or resisting with violence, but rather the interference charge without violence. That was the charge that was assigned within the four corners of the affidavit to her father, who was also on the scene at the time.
And Your Honor, with regard to the interference, the state has no objection should the court wish to ROR her on that count only.
All right, that would be so ordered. Want to finish reading this again?
Oh, sorry. And of course, Your Honor, I was hoping to ask about the battery on law enforcement. Within the four corners of the affidavit, it was written that my client swung arms and legs at the officer, but the officer did not record that these attempted swings actually connected or did institute a battery.
Let's see, it says on the final page that Nina was resisting arrest, shoved the cop, and was tased. So it would appear the battery charge would be indicated. Now, would the state please go over again what you were requesting or
Yes, Your Honor.
stating as to the release bonds?
Your Honor, the state requested that bond on count 3 be set at $2,500.
Right.
Count 1 at 150, count 2 at 100. The state would recommend as to count 4 that she be ROR'd and count 5 be at $100.
All right, all facts considered, that would seem appropriate and would be so ordered at this time. And I believe I said earlier, this is Division 22. All right, the next file I have is that of Joel Menjivar. Is that you, sir?
Huh?
Is that you?
Yes.
Your name?
Joe Manjibar, sir.
All right. Now, is there an offer from the state?
Yes, Your Honor. Based on the fact that he has no criminal history, the state's offer is a withhold of adjudication, credit time served, which would be 2 days.
All right. Mr. Menjivar has also requested appointment of the Office of the Public Defender. That is ordered at this time. And what would court costs be?
Wait, you asked.
I'm sorry, since the public defender was not assigned at this case, I can only note as an aside that the offer was made to Mr. Menjivar for a withhold and credit time served, which means he would get out today, and the withhold means it does not go on his record, I believe. He would have to plead no contest to accept this deal, I believe.
All right. Now, Mr. Menjivar, is that what you want to do?
Yes, sir.
All right. Adjudication withheld, 2 days, credit for time served, $273 in court costs payable within a year.
The public defender was not assigned on this.
Yes,
I was,
the
or was?
public defender was
Okay,
appointed.
very well, then let me sign. Sorry, I didn't hear, it's very quiet. One moment, apologies, Your Honor, for the delay. Okay, so Mr. Menjivar has- The judge will ask a few questions. Apologies for the delay, Your Honor.
All right, the next file is that of Mark Edwards.
Oh,
Is that you, sir? What is your name?
Mark Nichols.
Mark Nichols, yes. Mark Edward Nichols. All right, sir, you've got a camping charge, bond $250. Is there an offer from the state?
Yes, Your Honor. It's an adjudication of guilt, 5 days, 2 days credit time served, and court costs.
All right, sir. Now, do you want me to appoint a lawyer for you?
Yeah.
Public defender appointed? Would those court costs also be 273?
My client would like to accept the state's offer and enter a plea of no contest.
All right. There is a factual basis stated, adjudication of guilt, 5 days Orange County Jail, credit for 2 days, time served, $273 court costs payable within 1 year.
Wait.
All right, next file I have is that of George Callaway.
Yes, sir.
All right, sir, you are presently out on bond. That bond or ROR, in any event, that is stayed. You have a new case involving a charge of simple trespass. Is there an offer from the state on that case?
Yes, Your Honor. It's an adjudication of guilt, 5 days, 2 days credit time served, no return to the Orlando Public Library at 101 East Central Boulevard. And court costs, abide by all trespass warnings.
All right, I now have the financial affidavit, public defenders appointed. So, Mr. Callaway, what is it you wish to do in regard to this trespass case?
Well, I won't return no more. I'm going back home.
Do you wish to enter a plea?
Yes, sir.
Okay, we're gonna plead no contest. My client would like to accept the state's offer and enter a plea of no contest, Your Honor.
All right.
I go home.
There's a factual basis stated here. So there would be an adjudication, 5 days, credit for 2 days, time served, no return to that location, which is 101 East Central in Orlando, $273 in court costs payable within 1 year. All right, your name, sir?
Antoine Bernard O'Neill.
Did Mr. Mecklish Williams bond out? Oh, okay, thank you.
All right, it would appear, let's see, there's no application. Hmm?
That's on here, I don't know.
Okay. That guy, I think. Okay. All right, now, let me inquire of the state. We have a battery charge, disorderly conduct, and so forth. I assume with a battery charge, there's no offer from the state?
There is no offer, Your Honor. That's
Wait,
correct.
hold on.
But, Your Honor, who is this?
This is.
Neil Antoine? Okay. I just switched back to Mr. McClish. Okay, there is an offer for Antoine Neal, Your Honor. And that offer is an
Wait.
adjudication.
Hold on.
I think they might be out of order.
All right, go ahead.
That would be an adjudication, 10 days, 2 days credit time served, no return to the scene, which is the Chevron station at 4252 South Orange Blossom Trail.
Yes, ma'am.
Abide by all trespass warnings, and the statutory 1-year driver's license suspension.
All right, now, Mr. Neal does have his application for criminal indigent status completed, so the public defender's appointed. Clerk cost $273.
3 days, so we'll be starting tomorrow.
Sir?
Your Honor, my client would like to accept the state's offer and enter a plea of no contest.
All right. Then the plea would be accepted. There is a factual basis. There would be an adjudication of guilt. 10 days, Orange County Jail credit for 2 days' time served. No return to this location at 4252 South Orange Blossom Trail. Obey all trespass warnings. 1-year driver's license suspension is ordered. Court costs $323 payable within a year. 30 days to appeal. If you cannot afford a lawyer, one to be appointed.
Thanks,
Sir, your name, please?
Michael Albert Dabrowski.
All right, you're out on bond here. That bond is stayed. You have a new charge. Petty theft, bond $500. Resisting an officer without violence.
Apologies, Your Honor, if I may inquire, are we on Michael Dabrowski's case today, or are we on someone else's?
Yeah, there's another guy out there that's Polish too.
All right, perhaps I misunderstood. Your name, sir?
Michael Dabrowski.
All right.
Dabrowski.
All these appear to be out of order. All right, sir, you have not been appointed counsel. All right, I'm advised. Now, you have a form, so the Office of Public Defender is appointed, and you do have a charge of aggravated battery, bond $3,500. So, do you want me to appoint the Office of the Public Defender to represent you?
Yes, sir.
All right?
I
So
just
ordered,
spoke to them.
and that's, Division 20.
Right?
All right, that's all for the moment then, sir.
Just call those two and they'll tell you what happened to them, because that's why they're not here. Just go ahead and call those two on the record. I don't think they're here.
Okay.
I don't know where they are, but.
All right, I'm going to just have a check here as to who is here and available to be called. William McLeish, is that individual? All right, reset. And Venus Deny? Reset. Next file I have is that of Eddie Smith.
Yes, sir.
Is that you, sir?
Yes, sir.
All right, sir, you've got an arrest warrant here, burglary of an occupied structure, bond $5,000, petty theft, bond $1,000. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed, Division 12.
Apologies, Your Honor, one moment. One second, let me double check. What was your name, sir? All right. Felony? Oh, Smith, I apologize. That would explain the confusion. Oh, there it was at the bottom. I hadn't seen that final small one for some reason. Apologies, Your Honor. Okay. So my client was appointed a public defender, or?
Yes.
Thank you, Your Honor. Apologies, there was a mix-up in the sheets. Were the bonds stayed?
Yes.
Thank you, Your Honor. All right. No, I wrote the confusions earlier. All right. Here's what we're dealing with at the moment, sir. And with the $5,000, you want to call our number to help you out with that, sir. Seems like you have a lot of stuff you're dealing with at the moment, so it may take a while, but I'm almost. All right.
All right, next file is that of Carl Dallas. Is that you, sir?
Yes, sir.
All right. Trespass on property after warning, bond $500. And the public defender is appointed. Offer from the state.
Yes, Your Honor, it's an adjudication of guilt, 5 days, 2 days credit time served, no return to the Days Inn at 2500 33rd Street. Abide by all trespass warnings.
Apologies, Your Honor, I don't think I was given any paperwork on this, at least any heads up. Okay, here he is, Mr. Carl Dallas. Apologies, he wasn't listed in the move-ups. Very well. So, oh, there. All right, apologies. So, Mr. Carl Dallas, well, adjudication?
Adjudication, 5 days, no return to the scene, which is the Days Inn. Abide by all trespass warnings and court costs. He has 2 days credit time served.
All right. All right. Was a public defender, Your Honor, was a public defender appointed to this case, or?
Yes.
All right. All right, so. 5 days. And My client would like to accept the state's offer and enter a plea of no contest.
All right. Then there would be an adjudication of guilt as to this trespass charge. 5 days Orange County Jail credit for 2 days time served. No return to that location at 2500 33rd Street. $323 in court costs and abide by all trespass warnings. That court cost item would be payable within 1 year.
All right.
All right, next file is that of Leopoldo Colon Ortiz.
Yes, sir.
All right, sir, you've got a Polk County warrant. And it alleges, it would appear that you failed to appear for arraignment on a trespass. So you'd be transported, your bond is $500, by the way. So if you don't post bond, you'll be transported to Polk County to answer to the charges there.
All right. Okay. Are you-
All right, the next file I have is a motion for discharge on Jeff Washington.
Yes, Your Honor. Let's see here. This is a motion to discharge. The accused was arrested December 7th, 2018. The public offender affirms that the time for a timely speedy trial expired March 7th, 2019. And we argue that the state did not file formal charges by information before the speedy trial time expired. And therefore, the court must discharge the charges against the accused. Under the precedent set in State of Florida v. Williams, a speedy trial begins to run when the accused is taken into custody and continues to run even if the state does not act until after expiration of the speedy trial period. The state may not file charges based on the same conduct after the speedy trial period has expired, Your Honor.
State?
Yes, Your Honor. The state concedes that we did not file a timely information in this matter, and the court should discharge this matter.
All right, so ordered.
Good luck, sir. Oh, apologies, sir. Let me just take that report.
All right, the next file I have is that of William Baston.
No, Your Honor, the Joseph Radosky, Radosky.
Is that Joseph Radosky?
That's correct, Your Honor.
All All right, now that paperwork, let's see. All right, a judge signed a warrant, no bond, with no contact with the alleged victim. So,
That's accurate. He was arrested on a felony charge on a warrant, which is domestic related. He's been held without bond for over a week now until he gets extradited from Melbourne to Orlando. I've spoken with the state, and they have agreed to set bond in the amount of $3,500 with the conditions of no contact with the alleged victim, Lois Radowski, that he not be allowed to return to the address of 734 Cedar Forest Circle, Orlando, Florida 32828, and that he not be allowed to possess any firearms or weapons.
all right, and for the record, state,
Yes, Your Honor, that is the agreed upon agreement. Mr. Radowski is entitled to a bond in this matter, and this is domestic related, Your Honor.
all right, then the bond would be set at $3,500 with no victim contact, no return to the address wherein the victim resides, and possess no weapons or firearms.
Thank you.
Thank you.
Sir, could you announce your name for the record?
Yeah,
please?
first name is Matthew, last name is Ferry, Ferrry, and there should be a notice of appearance in his case. Thank you.
All right, your name, sir?
Jean Benoit.
Say again?
Jean Benoit.
Want to make sure I understood. Did you say Jane Benoit?
Yeah, Jean Benoit. That's a Jean, last name Benoit. Benoit.
All right.
There's no
We
middle
got two cases here. One is driving while license suspended, bond $2,500. And the other is possession of ammunition or electric weapon by a convicted felon, bond $5,000. Then also possession of ammunition by a convicted felon, bond $5,000. Do you want me to appoint a lawyer, sir?
Yes, sir, because
All right, the Office of the Public Defender is appointed. We have Division 14 on the Dwillis, and on the weapons and ammunition, we have Division 15.
Your Honor, were all the bonds going to be stayed on these charges, or?
Let's see. It would appear perhaps appropriate to reduce count 2 bond on the possession, the count being possession of ammunition by a convicted felon. Count 1 on that case is possession of a weapon. So, input from the state?
Yes, Your Honor. The state would ask the court to stay bond in count 1 and set count 2 at $150 as a subsidiary of count 1.
So ordered.
And also put an order in, possess no weapons, firearms, or ammunition.
That would be granted and so ordered.
Your Honor, were we here on the driving while license suspended charge, or just the possessions of weapons and ammunition?
Both. Both.
Understood. We're staying the bond on the license issue, or?
2,500.
5,000 for the first charge of the possession, and a reduction to 150 for the subsidiary charge?
Okay, on the other case, the weapon is 5,000, count 1, 150, count 2.
Thank you, Your Honor. All right. All right.
All right, what is your name, sir?
Michael Bristol.
Did you say Michael Bristol?
Yes.
All right, sir. Several allegations here, or counts. Burglary of an occupied structure, bond $5,000. Petty theft with 2 prior convictions, bond $150. Fraudulent use of personal identification information, bond $150. The same, let's see, and then, let's, a total of 6 counts of fraudulent use of personal identification information. And the bonds on each of those are $150. So we have bonds of $5,000, $150 times 7. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, public defenders appointed. That's Division 16. Your name, sir?
Albert James Berman.
All right, Mr. Berman, sir, you have 2 sets of charges here. Failure to appear, and you're in a no bond status on that. And then you've got another case, or a set of charges, failure to appear, no bond on either of those. All right, public defender was previously appointed. That's, all of these cases are Division 15. All right, your name, sir?
My name is Shenard Butler.
All right, Mr. Butler, sir, you've got a case involving grand theft third degree, more than 300, less than $5,000. Your bond is $2,500 at this time. Do you want me to appoint a lawyer for you?
No, sir.
Public defender is appointed, that's Division 17.
Judge, she qualifies for PTR.
All right, so ordered.
Any conditions, anything?
Any requests by the state of special conditions on
Yes,
this?
Your Honor. No return to the Mall of Millennia and no contact with any witnesses and/or victims.
All right, that would be so ordered. Appears appropriate. Your name, sir?
Hernando Correa.
All right, sir, you've got a set of charges here. Robbery by subsequent force, bond $5,000. 3 counts of petty theft, bond $100 each. A charge of battery, $100, and resisting a merchant, $100. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defenders appointed, Division 10.
Your Honor, we'd ask that there be a no return to the super target at 2155 West Town Center Boulevard, and no contact with any witnesses.
All right. No return to 2155 West Town Center Boulevard or contact with any victims, witnesses.
Your Honor, if the defense may be heard, my client does not have any great criminal, does not have very many priors. Would it be possible for a bond reduction as to count 1, to the court's best estimation of what would be more appropriate?
And Your Honor, if the state may be heard, this is a crime that did include force, therefore version of violence, but also while it is a limited history, Mr. Correa does have a prior failure to appear in his history. The state would ask the court to stay the bond.
Your Honor, the defense is not asking that the bond be removed, only reduced. My client is only employed part-time, and he will likely be able to continue employment once he is released. A lower bond would still ensure that he is committed to returning to court.
The bond would be reduced to $3,500 on that count 1.
Yes, Your Honor. You're gonna want to talk to public defender when you can on these matters.
Your name, sir?
James Crum.
Mr. Crum, sir, you've got a set of charges here. Burglary of an occupied structure, bond $5,000. And the same charge, once again, bond $1,000 on that. An arrest warrant was issued in regard to this by a judge. And do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right. Public Defender appointed, Division 10.
Say it again.
One moment. Also, I would like to make the court aware that I think there was a clerical error on the face of the affidavits. It listed, it did not list a petty theft on it, but rather 2 copies of the first count, or there may have been a reduction. But the,
It's also there on the affidavit, Judge. Go back to page 1.
Hmm?
yeah, all right, I'm sorry.
Is this an add-on? It's an add-on.
All right, let's see, burglary of an occupied structure and petty theft. Ah, yes, with 2 prior convictions.
Apologies, Your Honor, that was not the portion I was referring to. It was merely a concern over the original complaint sheet, which was remedied in the current sheets. The defense would withdraw the request to investigate at this time. All right, so these are the bonds we're currently.
All right.
Sorry, the original part was my execution. It's not an issue right now, but we are here for you. Apologies for the.
Your name, sir?
Jeremy Delano.
All right, sir, you've got a charge here of uttering a forged check. Your bond is $1,000. I don't have an application for criminal indigent status.
We have one.
Oh, I'm told we do have one. So do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defender is appointed, Division 10.
He qualifies for PTR.
Your Honor, the state would just ask, as the court makes that consideration, that the court take into account that he has 6 convictions, 4 felony convictions, 2 misdemeanor convictions, a prior failure to appear, and his convictions include theft crimes as well, Your Honor.
Well, there would be no PTR on that under those circumstances.
Your Honor, I believe there's a, wait, did the state say there were 6 or 4? Because I'm only reading 4 with regards to felonies. I believe it was only
I
one.
said there's 6 convictions. I didn't break it down into 4 and 2. But if you'd like for me to break it down, it's 4 felony convictions, 2 misdemeanor convictions, 1 prior failure to appear, and the 15 unknown that I spoke of.
Your Honor, my client only has the single failure to appear. In this matter, I do not believe that it rises to a possible risk of flight. He is employed full-time and has been employed full-time for 3 years, self-managing. I believe he has sufficient ties to the local community, and I believe that there is grounds in this case. I believe he should still qualify for PTR despite the prior listings.
The court's previous finding and order would be sustained and stand at this time.
Understood, Your Honor. All right, so, yeah. So you- All right, so. Why is, you want to talk to bond? Sorry, number, you're gonna call us. I want to wish you good luck.
All right, sir, your name, please?
Deontay Florence.
All right, Mr. Florence, you've got a case here involving a charge of second-degree murder and commission of felony. The judge signed the arrest warrant, and you enter no bond status in regard to that. The bonds on your other case are cases or charges are stayed. And do you want me to appoint a lawyer for you, sir?
Yes.
All right, Office of the Public Defender is appointed, and that's Division 19.
Your Honor, if I may, I believe Mr. Florence's parents are present, and his mother wishes to be heard, Your Honor. I don't know if it's as to bond or not, or as to appointment of attorney. I believe she wants to be heard as to appointment of attorney.
All right. Anybody that's going to testify at this time, please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please state your names for the record.
Kizzy McGee. H.W. Ward.
All right. All right, ma'am, go ahead.
I'm just here about give my son a bun. He need a bun. He's a full-time student. In this case that they got him mixed up in, Lord, please let my son come out so he can go to school. He's on his way to graduate. It's just a lot going on with this, so I'd rather have him there from the outside and let him go to school and not miss no more days.
Your Honor, I would appreciate if you would take into consideration, he was in school at the time of his arrest doing both of these past incidents. He's not a threat to the community. We would consider if you would release him on bond, stay the previous bond, release him on bond, and if you would consider even a home monitoring, if he could come home with a ankle bracelet, but let him finish school. He's in high school. He's a senior, and he's working very diligently to finish high school. Give him a chance to finish high school,
With a
even if it
job.
involves, and he has a job too. He's employed also. And if you would just give him a chance to finish school, and we would be very conscious of and appreciative if you would give him a chance to even consider monitoring, because he's not a threat to and this is an ongoing thing, so we sure it be resolved at some time, but at this time, we would like to have him home.
Thank you.
Thank you for the time, Your Honor. Thank you for considering and giving us a chance to speak.
All right, you're welcome. All right, anything further from the defense,
Yes, the defense would be heard on a matter before this proceeds further. I believe there is cause for a probable cause concern in this matter. My client is listed under second-degree murder with in the commission of a felony. However, this charge requires that my client have been in a part of the perpetration or attempt, but I believe that within the four corners of the affidavit, neither element is sufficiently listed. My client was not sufficiently shown within the affidavit to be working with the decedent in this instant commission. All the state can show is that my client was walking away as the tragedy unfolded. I do not believe that the state has reached the required burden to show that there was probable cause to charge my client with second-degree murder in the commission of a felony.
State?
Yes, Your Honor. As to the matter of probable cause has previously been found, as this is a warrant arrest. However, the state would go on to argue to the court or assert to the court that within the four corners of the affidavit for the arrest warrant on which probable cause was found, there are identifiable witnesses, victims, and substantial facts that the state would ask the court to find that proof is evident or presumption is great that Mr. DeAndre Florence is indeed the individual that is identified within that warrant. The state asks, based on that the court continue to hold him at no bond status.
Well, at this time, the court would enter an order providing that as to this case, that is the second-degree murder case, that the defense request would be denied. However, that would be without prejudice to seek further relief in that regard.
Your Honor, in the alternative to the defense's original request, would the possible posting of a bond for my client be possible? As you saw, his parents were willing to take him in and even help pay the bond. And of course, they suggested, and I believe it may be proper, home supervision and arrest within the reasons outlined by the court. My client is still in high school. And of course, an absence at this stage from such a vital institution would be damaging to his long-term prospects. I do not believe he is a flight risk, especially if proper precautions are taken.
Well, the court would stand by the prior ruling, and I would again state that is without prejudice to seek further relief before the judge to whom the case is assigned.
Understood, Your Honor. Thank you for your time. All right. So we're currently at on. This is not going to matter. You're the one that calls as soon as you can. I want to wish you.
Your name, please?
Sharia Johnson.
All right. Did you say Sharia Johnson?
Yes, sir.
All right.
Hornsby bonded.
Hornsby bonded? Okay. All right, Ms. Johnson, you've got a case here involving an allegation of introduction of contraband into a county facility. Your bond is $500. Do you want me to appoint a lawyer for you? All right?
Oh, yes, yes.
Office of the Public Defender is appointed, Division 19.
If the defense may be heard, a ID of my client or an interview was not completed, and it does not say for certain if she does or does not qualify for PTR. Does records have anything on this matter at this time, or? Okay, understood. All right. All right. Your Honor, apologies. Were we staying the bond on my client's case?
Yes.
Thank you, Your Honor. Apologies for not hearing earlier. All right. That's the number you're going to call.
Your name, please?
Kiara London.
You say your last name is London?
Yes.
Okay. Ma'am, looks like several things here. Possession of alprazolam, bond $1,000. Possession of cannabis, bond $1,000. Violation of probation and out-of-county situation. Let's see. It looks like Seminole County. And then a violation of probation out of Polk County. Now, ma'am, do you want me to appoint a lawyer to represent you in regard to the Orange County case?
Yes.
Do you want a lawyer appointed?
Yes.
All right. Office of the Public Defender is appointed. That's Division 11 for the Orange County case.
Your Honor, may the state be heard as to bond in that matter?
Yes.
The state would recommend that the court stay bond on count 1 and treat count 2 as a subsidiary at $150, Your Honor.
Well,
Or
that
at
seems-
$100, I'm sorry,
It
Your Honor.
seems appropriate. $100 count 2.
Your Honor, if the defense may be heard, my client has business in the Polk County complex where her probation was originally set. If my client would put her on ROR for the 2 charges we are looking at right now, she can be sent to Polk County immediately to face the judge on her probation issues.
You're talking about the other county.
Yes, the other county. The other county is currently dealing with probation matters on her. Releasing her on ROR would simply mean that she is shipped off to Polk County immediately without any wait.
All right, and states,
Your Honor,
Is it-
I'm not certain that that is accurate, as these are on-view violations of probation. However, the state would object to ROR release, Your Honor, as she is, when she committed this crime, she was on probation in 2 different counties, Your Honor.
well, there might be an issue as to this court's jurisdiction on those other circuit cases, but in any way, in any event, we're going to leave it as is, as previously stated.
Understood, Your Honor. All right, we're looking at 1,000.
If I can situate it like 20 days in jail, 30 days, trying to make me agree for these charges, which I didn't do.
If I may inquire as to records, would my client be remaining within this complex until the bonds are settled and then be able to be transported to Polk County? All right, we're gonna have to pick this up here, ma'am. All right. I wish you good luck. Call our office when you can.
All right, ma'am, your name, please?
Kaylin Lyons.
All right, Ms. Lyons, you've got a set of charges here. Possession of cocaine, on which your bond is $1,000, and possession of paraphernalia, bond $100. Do you want me to appoint a lawyer for you?
Yes.
Public Defenders appointed, Division 10.
She qualifies for PTR.
And, Your Honor, the state would ask for random urinalysis should the court
All
release her
right,
on pretrial.
PTR with RUAs.
What do I do now? Thank you.
Good luck.
Thanks.
Call us.
All right, your name, sir?
James Albert Miller III.
All right, sir, you've got a couple of matters here. One is a new case involving charge of petty theft with 2 prior convictions. Bond is $2,500. And once again, petty theft with 2 prior convictions, bond $2,500 on that case also. These are different, or separate cases, it would appear, 2 arrest warrants. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, public defender is hereby appointed. First case is Division 17. The second case is Division 11. All right. Now, sir, your name, please.
No, Your Honor, this is Mr. Miller. I just need clarification if you were staying the bonds. Understood. Thank you. All right. All right. There you go, sir. Good luck. I'll ask when you can. All right.
Hmm?
You stayed.
Clear the way, sir.
Yes. The bonds are stayed. All right, now, your name, sir?
Carlos Polanco.
All right, sir, you've got a failure to appear capias. And at this time, you're in a no bond status. Do you already have a lawyer on that case?
Yeah, I had a public defender.
All right. And for information purposes, this is Division 17. And as I say, you are in a no bond status as previously set by the court.
So I wouldn't get no bond today?
You're in a no bond status. You, without a court order changing that,
But
you can't post a bond to get out of jail.
I have a question, because I was supposed to go to court the 12th. The 12th. And my public defender told me I didn't have to appear. I literally work on Livingston and Terry, down the block from the courthouse. He told me I didn't have to appear, and that's why they put out that warrant for that.
All
Then
right.
they told
Well,
me-
you may certainly bring that before the court, but here today, that's all we consider right now. All right, your name, sir?
Calvin Spangler.
All right, so you've got a set of charges: possession of methamphetamine, bond 1,000; possession of cannabis, bond 500; possession of prescription drug without a prescription, bond 500; and possession of paraphernalia, bond 500. And do you want me to appoint a lawyer for you, sir?
Yes, sir.
Office of the Public Defender is appointed. That's Division 20. Now, does the state have any input as to the amount of bonds on counts 2, 3, and 4?
Yes, Your Honor. The state would recommend subsidiary bonds at 100 for count 2, 100 for counts 2, 3, and 4, Your Honor.
That appears to be appropriate and would be so ordered. Now, that's Division 20 if I have not previously announced it. Your name, sir?
Torres Summers.
All right, Mr. Summers, sir, you've got a case here involving failure to report name or residence change as a sexual offender, and a warrant was issued. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defender is appointed, Division 17.
And, Your Honor, if the state may be heard as to bond,
Yes.
as this is the first failure to report, the state would recommend a bond of $3,500.
All right. Bond would be set at $3,500, but sir, be certain to register. And Your name, sir?
Richard Turner.
All right, Mr. Turner, a couple of cases here. Violation of condition of pretrial release, no bond, and the same allegation here, again, no bond. And do you already have a lawyer representing you, sir?
I believe so.
Public defenders representing you. So Division 17 on the first case and 20 on the second case. All right, Justin Upton?
Yes, sir.
Sir, you've got looks like a couple of cases here. Failure to appear. Let's see, 4 counts on the first case, Division 10, and then introduction of contraband into a county facility, bond $1,000. And then yet another case, possession of cocaine, heroin, resisting without violence, and petty theft. Bonds are $1,000, $150, and $100 on 2 counts. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Public defenders appointed. We have Divisions 10, and Division 19 on the contraband allegation, and Division 12 on the cocaine, heroin, etc. Robert Washburn.
Yes, sir.
All right, sir, you've got a case here involving several charges: burglary of a conveyance, bond $3,500; obtaining credit cards through fraudulent means, bond $100; and fraudulent use of a credit card, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defenders appointed, Division 19.
Your Honor, would all bonds be stayed on this case?
Yes. All right, sir, your name, please?
David Williams.
Mr. Williams, a set of charges here. A battery on an officer or firefighter, EMT, et cetera, no bond. Resisting an officer without violence, no bond. Resisting an officer with violence, no bond. And resisting an officer or interference with a law enforcement officer without violence, no bond. And disturbing the peace or breach of peace, no bond. And do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defender's appointed, that's Division 20. Now, does the defense have any comments?
At this time, Your Honor, the the defense does not have any comments on the facts of the case. All charges seem to have been filed with some degree of probable cause by the state. However, my client is employed part-time in the local area with electro manufacturing. And of course, he has significant ties to the local community. I believe you saw his daughter earlier. I believe he has a reason to stay in the local area. Could he be allowed on bond on the named charges if he does not qualify for PTR? All right. But yes, I believe his daughter would have an easier time making bond if Mr. Williams was allowed out to continue working. Just to clarify, defense is not asking for RR or PTR at this time. Defense is simply asking for bonds to be placed upon the charges my client is currently facing.
All right, input from the state.
Yes, Your Honor, if I may have just one moment. Your Honor, the state would ask the court to set bond as to count 3 at $2,500. Treat counts 1, 2, 4, and 5 as subsidiaries. And that would be 1 and 2. Count 1 at $150, count 2 at $100. And $100 each for counts 4 and 5. So it'd be $2,500, $150, $100, $100, and $100.
Your Honor, while the defense is grateful that the state was willing to make an offer at this time, was willing to put forth stated bond values, would it be possible for the court to consider a slightly lower bond on the primary, because my client works part-time, and of course, on this case at hand, the facts of the case do not show that a high bond would be required, or should be mandated, I believe.
Well, the court, considering all the facts here, would grant the state's request $2,500 bond on count 3, 150, count 1, 100 on counts 2, 4, and 5. Division 20, if I didn't announce that earlier.
Understood, Your Honor.
Can you tell me if we did that? Okay. Ah. Okay, we'll reset. All right, next file I have is that of Stephen McCarter.
Yes, sir.
All right, this is disorderly conduct. Is there an offer from the state on this case?
Yes, Your Honor, the offer's 7 days Orange County Jail, 2 days credit time served, and court costs.
All right, public defenders appointed qualifies. Public court costs for.
My client would like to accept the state's offer at this time and enter a plea of no contest.
All right. So, sir, do you understand you'd be giving up your right to a trial if we go ahead with this?
Yes, sir.
All right. In regard to this allegation of the city ordinance, there would be an adjudication, 7 days Orange County Jail, credit for 2 days, time served. Court costs, you said $273 payable within a year. Next file I have is that of Jeremy Roberts.
Yes, Your Honor.
Sir, you've got a soliciting charge here. The bond is $250. Is there an offer from the state?
Yes, Your Honor. 7 days, 2 days credit time served, adjudication of guilt, and court costs.
I didn't hear the third thing.
Adjudication of guilt
Right.
and court costs.
Yeah.
So it'd be 7-2.
$273.
So, and I before my speech, we would. Otherwise, the bond is just that we want to, you know, like.
I'm accepting the offer.
Very well. My client would like to accept the state's offer at this time and enter a plea of no contest.
All right. There's a factual basis, the plea would be accepted, adjudication of guilt, 7 days, credit for 2, court costs $273, payable within 1 year.
All right, sir, I want to wish you good luck.
All right, your name, please?
Krista Mel.
All right, Ms. Mel, you've got a case here involving an allegation of petty theft. Your bond is $250. Do you want me to appoint a lawyer for you?
Please.
Public defender's appointed. I don't know if there's an offer from the state on this sort of case.
There is, Your Honor. And the offer is an adjudication of guilt, 7 days, Orange County Jail, 2 days credit time served, and no return to the Home Depot at 6130 East Colonial Drive. Abide by all trespass warnings.
If the defense,
All right.
if the defense may be heard, would the state be willing to consider a lesser sentence in days, considering my client does not have a very extensive history on this matter?
Based on the facts of the case, no.
No?
No. 7 days.
Understood. Yes, you could. Okay, so you have two options. One, you can bond out that $250. That is what you like to look at. So if I believe this is not what they should be fighting against the court. For the state plus structure. Or two, the state's deal. This would mean the case is strong. It goes on your record. This is an example. So, say steals 3 packs of singles on 3 different occasions. That turns into a felony. I don't want you seeing serious jail time for the back of singles. Okay, so that's an enhanced offense before that. That would go on your record. So you can either get this adjudicated, that goes on your record, but then you will only have to spend 4 more days of today and until, and 4 more days to get it out.
Oh, would the court cost be $273 on this?
All right, so you pay the bond, you're gonna tell the defender, you're gonna find the charges. You don't wanna get this. All right. So we're clear. This drops the case, but you would have 24 days to just stay and then. My client would like to ask if the court has recorded that the bond for this was set at $250.
Yes.
All right. A moment to confer. Very well. My client will opt not to accept the state's offer at this time and will instead pay the bond on this case.
All right.
Okay, that one on. We have 250. Right. Here, one and 5. Okay, bond payment would be minimum 100. I'm sorry. They won't give it to you for 25, but they can have it for 1. They won't see that 100. So if you said want to give it to 50, then just get those 50, and if you take $25.
Thank you.
Your name?
Jerry Como.
All right. Ma'am, you've got a set of charges here. Possession of cannabis, bond $500, and possession of paraphernalia, bond was set at $500. I'm reducing that to $100. Do you want me to appoint a lawyer for you?
Public defender, a public defender, I guess.
Yes, public defenders are lawyers. I'll appoint Office of the Public Defender, Division A.
So it should be like 100. Okay.
If you have a lawyer, call us. Be sure to call our office when you can. Thank you.
All right, your name, please.
Trisha Davis.
All right, Miss Davis. You are out on two bonds. The bonds, and each of them are hereby stayed. You've got a new case involving petty theft with prior theft convictions, bond $500 as to that. Now, do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, and Division A.
Okay.
Your name, please.
Alexia Delaney.
All right. You have an out-of-county warrant here, Osceola County. Your bond is $500 for failure to appear for arraignment on a petty theft case. So you either post bond or you'd be transported to Osceola County to take care of the charges there.
Morning.
All right. What is your name?
Yashika Williams, sir.
I'm sorry? Ah, all right, reset. And let's see, the only file I have left is that of William Thompson.
And that's all the state has left as well.
Same for defense.
Okay. All right, sir, your name, please?
William Hill Thompson.
All right, Mr. Thompson. Sir, you've got a case here involving an allegation of threatening or throwing a discharged destructive device bond $5,000. Do you want me to appoint a lawyer for you, sir?
Yes, I do.
All right, Office of the Public Defender is appointed. And it says here, Division DKB.
Division 11.
Huh?
Division 11.
Division 11.
Right now, we're gonna have your charges, your bond, and then
How do you like this time change?
good luck.
I'm with you. All right, 33-day motions. Trayvon Lewis, case ending in number 1946.
A moment, Your Honor, to get everything into position. I apologize for the delay. Oops. Goodness.
Counsel ready?
Yes, yes, I am.
Oh, okay.
With regard to Trayvon Lewis, case ending in 1946, and information has been filed. Filing ID is 86167503. The state asked the court to deny the motion.
So ordered. Next case is Orlessa Dixon, case ending in number 1942.
And information has been filed. Filing ID is 86186311. State asks the court to deny the motion.
So ordered.
Apologies. With respect to state's reasons, were dates attached to the reasons given?
I'm
Or-
sorry?
Were dates and times of the filings attached to your lists?
I can provide the date, but I provided the filing ID, which is from the clerk's office, which is confirmation that it has been filed.
Understood. But for purposes of this matter, could the date be provided along with the additional information given?
Your Honor, does the court wish to have the dates provided along with the filing ID? The state generally gives the filing identification because that contains all of the information.
As an officer of the court will accept the representation of the state and the defense.
Understood.
All right, next case file I have is that of Lloyd Saylor, case ending in number 1044.
A no information notice was filed, and for a date on that, that was filed on 3/11/2019.
All right,
That should be granted, Your Honor.
Granted. Stephen James Marshall, case ending in number 1601.
A notice of non-filing was filed on March 11th. That should be granted.
So ordered. All right, Stephen James Marshall, case ending in number 1388.
A notice of non-filing was filed, and that should be granted. That was on 3/11.
So ordered. Stephen James Marshall, case ending in number 1981.
Notice of non-filing on March 11th. That should be granted, Your Honor.
So ordered. James Rogers, case ending in number 1083.
A no information notice was filed on 3/11. That should be granted.
So ordered. Eric Kennan, case ending in number 1903.
Notice of non-filing on 3/11. That should be granted.
So ordered. Kyle Ferretti, case ending in number 1943.
And information was filed. Filing ID is 86160756. State requests that that be denied.
So ordered. Tacita Coverdell, case ending in number 15759.
A no information notice was filed on 3/11. That should be granted.
So ordered. All right, Tacita Coverdell, case ending in number 1906.
Notice of non-filing was filed on 3/11. That should be granted.
So ordered. Tyrone Burley, case ending in number 2343.
And information was filed. Filing ID is 86208152.
All right.
That
denied.
should be denied, Your Honor.
Sean Manley, case ending in number 2059.
And information was filed. Filing ID is 86206690. The state requests that that be denied.
So ordered. Brandon Deshawn, case ending in number 1119.
Your Honor, that case was consolidated with number 16 on the list, Brandon Charles Deshawn, 2019 CF 1925, under which an information was filed. and a clocked-in copy has been provided to defense counsel via email this morning. And the state asks that the court deny 1119 and 1925, Your Honor.
So ordered. All right, let's see, what was the name of that one? Okay. All right, Sean Wilkins, case ending in number 1749.
An information was filed. Filing ID is 86199173. The state requests that that be denied.
So ordered. Brandon Deshawn, case ending in number 1925.
That's the one that we previously spoke of, and the state had asked the court to deny. That is the clocked-in copy of the consolidated.
Now, James Collins, case ending in number 1929.
An information has been filed. Filing ID is 86026768. The state requests that that be denied.
So ordered. Kayla Fields, case ending in number 1900. Oh, wait a minute, that's motion for release upon defendant's own recognizance, 30.
Yes, Your Honor, that's a 33-day notice, and that's by Regional Conflict Counsel. A notice of non-filing was filed on today's date. The state asked the court to grant that motion.
So ordered. And then another motion for release, Terrence Bauer, B-A-U-R, case ending number 1894.
A notice of non-filing was filed on 3/11. That should be granted.
So ordered. All right, I would inquire of the defense and state, how long before the next session?
For the next session, all cases have been reviewed. I would
All right, be seated, please. All right, we're on the record. If council would please announce their names for the record.
Good morning, Edith Bush for Session 2 for the Office of the State Attorney.
Fernando Paredes on behalf of the Office of the Public Defender.
All right, and sir, your name, please?
Timothy Lafferty.
All right, Mr. Lafferty, let's see, you've got a case here involving trespass after warning. Your bond is $500, and also possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
No.
No?
Public defender.
All right, public defenders are lawyers. They've gone to
Okay.
law school, passed the bar, and all that. So, Office of the Public Defender is appointed. Now, is there any, no, I suppose, there's no offer from the state, I assume?
There is an offer, Your Honor.
Oh, there is.
And the offer would be a concurrent offer on the two matters. It's an adjudication of guilt, 14 days with 2 days credit time served. In 2019 MM 2056, there would be a no return to the scene, which is the 7-Eleven at 3974 South Orange Blossom Trail, and abide by all trespass warnings.
Did you address the detainer?
I'm sorry?
Did you address the detainer? He's out on bond. Did you address that?
Not yet.
No, I don't.
You see the form, but it's on the front of the order. See the case number right now, front of the order?
Oh, yeah. And then the trespass. Oh, all right. Down on bond on case number 2018 CF 16943. And in regard to that, that bond is stayed. All right.
We need his plea form so we can sign it, so to accept the state's offer.
What did you say?
He's gonna accept the state's offer.
Okay. All right, so as I understand the state, adjudication, 14 days credit for 2, no return, and no trespass violations and court costs. Is that correct?
Yes, Your Honor.
All right. All right, so Mr. Lafferty, is that what you wish to do to resolve your cases here today?
Yes, Your Honor.
All right. Then there would be an adjudication as to each. There'd be 14 days Orange County Jail, credit for 2 days time served. No return to 3974 South Orange Blossom Trail. And obey and comply with all trespass warnings and court costs. $323 in court costs payable within 1 year. And that is concurrent. All right. All right, your name, sir?
Jeffrey Wayne Finley.
All right, Mr. Finley, you've got a charge of disorderly conduct. Your bond is $250. Is there an offer from the state?
Yes, Your Honor. It's an adjudication of guilt, 5 days. Orange County Jail, 2 days credit time served, and court costs.
Also, the Office of the Public Defender is appointed. So, what says Mr. Finley? And court costs.
My client would like to accept the state's offer at this time and enter a plea of no contest.
All right. 3, 273.
Sorry for the delay, sir.
All right, a plea having been entered, there would be an adjudication of guilt in regard to this disorderly conduct case. 5 days, Orange County Jail, with credit for 2 days' time served. Court costs $273 payable within 1 year.
You got 2 days to your record, so 3 more days. So it'll be days, Tuesday, Friday. Thank you. Good luck, sir.
All right, your name, sir?
David Lee Goins.
All right, sir, you've got a violation of probation allegation. You're in a no bond status at this time. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is appointed. That's Division 11.
It's on site, yes, sir, so good luck, sir.
Your name, sir?
William Johnson.
Mr. Johnson. Sir, you've got a set of charges here. Possession of cocaine, bond $1,000. Possession of drug paraphernalia, bond $100. Then another case on which you have a charge of open container, and that bond is $250. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, public defender appointed, Division 15 on the cocaine case, Division A on the misdemeanor. All right, sir, your name, please.
Michael LaValle.
All right, sir. Several things here. A charge of armed burglary of an occupied dwelling, no bond on that. Aggravated assault with a deadly weapon, no bond at this time. And charge of battery, no bond at this time. Then another situation here, a violation of condition of pretrial release. There's 2 counts on that, that violation of conditional pretrial release, and you're in no bond status as to that. Now, sir, do you want me to appoint a lawyer to represent you?
Yes, sir.
All right. Public defender is appointed, Division 17 on the set of new charges, and then on the PTR violation, no bond. Your name, sir?
Charles Malik.
All right, Mr. Malik, sir, you've got a new case here involving purchase of cocaine. In regard to the arrest report here, the bond for the purchase of cocaine was originally set at $1,000. It should have been $15,000. Then simple trespass, bond 100. Possession of paraphernalia, bond 100. Now, you're out on a charge of possession of controlled substance. That situation is stayed in that. Now, I don't have an application for criminal indigent status. Does council know if you've had prior representation?
Your Honor, he was represented in the case that the status was stayed upon, but I do not know if he is currently being represented on the case before the court today.
Well, what I will do at this time is to temporarily appoint the Office of the Public Defender to represent Mr. Malik.
Your Honor, it is the defense understanding that there was a clerical error and that the first charge would be not 1,000 but 15,000.
Yes, there's a Corrections Department inmate records management bail correction form that says that the bond should be set at 15,000 instead of 1,000.
Understood, Your Honor.
All right, state have any input on that bond issue?
Your Honor, that is the current schedule bond for sale, delivery, or purchase of cocaine. The state would ask the court to stay the bond.
Well, that's to count one.
As to count one,
that
and
the bond would be stayed on that cocaine. And then the other 2 bonds are $100 each.
and the court stayed the bond
Yes.
For the release conditions, yes.
All right, I want to get call us about this.
What is, this is not even a purchase. I didn't buy anything from anybody.
If I may request clarification to make sure that the clerical error was not as to the charge as opposed to the price. Did the state have probable cause on the purchase on this matter? I would need to double check on my, one moment, permission.
Are we back at Mr. Malik?
Yes, ma'am.
One moment, sir, one moment, sir. Let me double check something.
Your Honor, in rereading Mr. Malik's affidavit, there is no indication that this was purchase, sale, or delivery, as stated on the face sheet. The state would ask the court to modify bond as to count one, back to $1,000, and find probable cause for possession of cocaine. In rereading this, I do not see where there was purchase or an attempt to sell
All right,
the cocaine.
I would have missed that then, so that'd be $1,000 on count one, and then the $100 on each of the other two, and then well, looks like that's all in regard to Mr. Miley.
Sorry. I will go after this. All right.
Your name, sir?
I'm Rene Rivera Rios.
All right, sir, you've got a set of charges here. Possession of cocaine, bond $1,000. Possession of firearm in commission of a felony, bond $5,000 at this time. Do you want me to appoint a lawyer for you, sir?
Yes.
Public
sir.
Defenders appointed, Division 14.
And, Your Honor, the state would object to pretrial release, as this is a possession of firearm. And the state would be reluctant for pretrial release on a firearms charge. But the state would also like to be heard as to bond, Your Honor.
Go ahead.
The state would recommend that bond in count 2 be stayed, and that count 1 be treated as a subsidiary at $150, Your Honor, with a possess no weapons, firearms, or ammunition.
Your Honor, if the defense may be heard, my client does not have anything, does not have an extensive rap sheet and does not have anything on his record to say that he is dangerous. Surely, I believe that PTR would be appropriate in this instance, considering he has no failures to appear, and the case in question does not rise to the level where PTR should be completely discounted.
All right, I want to review this once again. All right. I've reviewed the allegations in the arrest affidavit. And on the cocaine case, the bond would be set at $150. And on the possession of a firearm, the possession of a firearm, period, the bond would be $5,000 with condition possess no weapons or firearms. That's Division 14, if I did not previously announce.
Apologies, Your Honor. If I may seek clarification, was the state recommending the subsidiary bond be set at 150 or 100?
150.
Understood. Thank you.
It's a felony.
All right. Fortunately, we're gonna have to put this down. Here's our number. You're the one I've called. So these are bonds for friends. But I want to wish you good luck. Calls from me, right? An attorney will be assigned to your case.
All right, your name, sir?
Craig Spurlock.
Mr. Spurlock, sir, you've got a couple of things here. Failure to appear on a petty theft with 2 prior convictions, and the judge set you in a no bond status as to that. And then another failure to appear, 3 counts on controlled substance type cases, and you're in a no bond status in regard to each of those. Say? All right, and the public defender was previously appointed. We have Division 16 on each of these cases. Your name, sir?
Owens, Richard Owens.
Say again?
Richard Owens.
All right, Mr. Owens, you've got a case here for failure to appear in court on a case. Your bond was set at $1,000 on this drug paraphernalia case. Now, do you want me to appoint a lawyer, or can you tell me if one was previously appointed?
That was, I was out on bond, never had a lawyer. That would have been my first appearance, but I got days mixed up. Thought it was tomorrow.
All right, does the, all right, I'm going to then appoint the Office of the Public Defender to represent you in regard to this. Your bond was set, as I say, at $1,000, and that's Division 83. Your name, please?
Barbara Jean Hayes.
All right, Ms. Hayes, you've got a case here involving an allegation of driving while license suspended or revoked. The bond on that case is $500. Now, do you want me to appoint a lawyer for you?
Yes.
All right. Office of the Public Defender is hereby appointed, says here, Division A. Your name, please?
Isaac Avilas.
All right, Mr. Avilas, sir, you've got a case here involving an allegation of possession of drug paraphernalia. Your bond is $500. Do you want me to appoint a lawyer for you, sir?
Yes.
All right. Office of the Public Defender is appointed, says here, Division A. And that's all I have on that case.
Your Honor, before we end proceedings, may I ask if State would have an offer for my client at this time?
Yes, the state does. It's an adjudication of guilt, 5 days, 2 days credit time served with court costs.
Right?
And what would the cost be, 273 or 283? 323.
My client would like to accept the State's offer at this time and enter a plea of no contest.
All right. And sir, do you understand you're giving up your right to have a trial?
Yes, yes, sir, I am.
All right. Then the plea would be accepted, adjudication of guilt imposed, 5 days Orange County Jail, credit for 2 days, time served. Court costs $323, payable within 1 year.
Since it's nearly the end, since it's nearly the middle of today, would my client be getting out this Thursday or this Friday, based on jail time?
Thursday, Thursday, that's fine.
Very well.
Does he have recording requirements?
Okay, right. Good luck, sir.
All right, your name, sir?
Larry Griffin, sir.
All right, Mr. Griffin, sir, you've got a set of charges here. Resisting an officer without violence, bond $500. Carrying a concealed weapon, bond $100. Possession of cannabis, bond $100. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defender is appointed, Division A.
And no, I do not have an offer.
All right, sir, your name, please?
Nicholas James Jordan.
All right, Mr. Jordan, your bonds on the drug charges on which you're released are stayed at this time. You have a new case involving loitering or prowling. You do not qualify for appointment of an attorney from the public defender's office. Is there an offer from the state
Your Honor, if the
for Mr. Jordan's consideration?
Your Honor,
Your Honor, based on the facts of the case, the state's not willing to make an offer at this time.
All right.
Your Honor, if the defense may be heard, I'm concerned about possible clerical errors. It says that Mr. Jordan has been unemployed for 2 months. Was that factored into the court's decision?
All right, well, the application for criminal indigent status provides that he has take-home income of $600 to $700 a week.
So at your job, when you were working, you were taking home 600 a week?
Right.
Okay, but you're not currently employed at this time?
Basically, yeah. I mean, I'm supposed to start work back next week.
Okay, so there was you might have miswrote something in your forms.
Okay.
Your Honor, it appears that my client was previously working at a company called Competitive Edge not my client, Mr. Jordan was working at a Competitive Edge Landscaping Company for 4 months, but that he has since taken a leave and is not technically employed?
Not technically employed. I came down with like cellulitis in my right leg.
So you're not making an income at this time?
So I don't have an income at this time. I'm supposed to start back work next week.
Okay. Apologies, Your Honor. It appears that everything is now on record. I will step aside unless the court appoints a public defender. Sorry, so that's all I can do at the moment. Everything appears in order otherwise.
Your Honor, though it wasn't sworn testimony, the only testimony that we heard was that he's technically not employed. He's been off for a week and he returns next week. So the state would submit that nothing has been stated that would indicate that his affidavit is any different than what he filled
I
out.
would concur. So, Mr. Jordan, you would not be appointed a public defender at this time. Now, should the situation change, then that could be reconsidered.
Okay.
But in the meantime, the new allegation here remains at a bond of $250, and you're out on bonds that have been stayed.
Okay. Now, quick question, Your Honor. The bonds that I was already out on, now is there any way, like we had just paid those I believe it was like last week or something like that, maybe 10 days ago. Are those gonna have to be paid again?
No.
Okay, so there's no action taken on those bonds, like I just have to pay the
On the existing bonds, that is correct.
Okay, so I just have to pay the $250?
Yes.
Okay, thank you very much.
And, Your Honor, the state would ask for a no return to the Park East Apartment Complex located at 7844 Silver Tree Trail.
Okay.
All right, that would be so ordered.
Thank you.
That's it. All right, your name, sir?
My name is Christian Rodriguez.
All right, all right, give me your name once again.
Christian Rodriguez.
Okay,
Billy Robinson, mental health, Your Honor.
See what?
Robinson Billy, mental health.
okay. All right, now, sir, you've got a charge of battery on which your bond is $500 with requirement, no victim contact. And do you want me to appoint a lawyer for you, sir?
I don't have financial.
He's asking if you want a public defender.
Oh, yes, please.
All right, public defenders appointed, Division A.
He qualifies for PTR.
And Your
All
Honor,
right.
the state would oppose PTR, as this is a crime of violence, and we have no victim input.
All right, then there won't be PTR.
Your Honor, if the defense may request clarification, was the bond stayed on this matter?
Yes, yes, it was.
Thank you, Your Honor. Apologies for this. All right. All right, so again, also attorney, if you have any questions, please. Oh, it's, you're going You do. You have been appointed a public defender. Sir, it's gonna be fine. It's gonna be okay, sir. It's gonna be okay.
All right, your name, sir?
My name is Jacques Moore.
All right, sir, you have a case involving trespass on property other than a structure or conveyance. Bond is $500 on that charge. Possession of drug paraphernalia, bond $100. And I don't see that any application for criminal indigent status has been completed by you. Does the Office of the Public Defender know if you represented him before?
We do not at this point have, on Mr. Jacques Jamiel Moore, we do not have any, I do not have anything at the moment, especially to these charges. He may have a public defender, but no, he does not have a public defender on these exact charges at the moment, to my knowledge.
Your Honor, if I may have a moment, I believe their office has represented Mr. Moore in the past.
So prior representation?
I believe so. If I may have just one moment, I can
All right.
verify that.
Yes. Okay, so my client appears to have filed for a PD.
Today, that was today, all this stuff we did today.
Oh, yes, that was the stuff. But
And
that-
yes, Your Honor, the Public Defender's Office has represented Mr. Moore
All
on
right.
several occasions.
Then, for purposes of this hearing, in this case at this time, Office of the Public Defender would be once again appointed.
But hey, if I have to, I represent myself, sir.
Don't worry, you have that one.
It sounds as though Mr. Moore wants to represent
It's
himself.
not a paraphernalia.
And Your Honor, it sounds as though Mr. Moore said he wanted to represent himself, and the state does have an offer and did convey it to the public defender previously. And that
All right.
offers
Ma'am.
adjudication of guilt, 7 days, 1 day credit time served, no return to the scene at 7/11, 5281 South John Young Parkway, abide by all trespass warnings.
Okay, hold on, so, actually, the public defender still been assigned on this? All right, so, looking at adjudication, that means the person has, otherwise you won't understand. 6.8. And, you know, counterfeit, court constitute, that's, maybe in a year, maybe 1.3. I use text.
And the state is requesting that be concurrent?
For each charge, yes, Your Honor. Concurrent.
Apologies for the delay, Your Honor. My client would like to accept the state's offer at this time and enter a plea of no contest.
All right.
A moment whilst I finish filling this out. There you go.
All right, then in regard to this case, there would be an adjudication, 7 days credit for 1 day concurrent. Hmm? Oh, 2 days credit for time served then. 7 days with credit for 2 days time served. No return to this location. 5281 South John Young Parkway, and commit no other trespass type violations. You do have 30 days to appeal. If you cannot afford a lawyer, want to be appointed.
All right. Thanks, sir.
Mhm. All right, I have one file left. It's on Derek Scherer.
Hospital, Your Honor. Hospital.
Oh, reset. All right, well, it would appear we finished for the day. So unless there's some objection, we will be in recess.
Thank
Till
you, Your
tomorrow.
Honor. No objection from the state.
Thank you, Your Honor. No objections from the defense.